Hi, my name is Ahmad Shazwan. Today, I'm going to be talking about business law cases, which is Koehler V Cerebos, and I'm going to be represent on behalf of my group, which is group number 32. Moving to the case introduction, the work stress psychiatric illness is not something new in this era, but it has been discovered ages ago in 1990s. On 6th of April 2005, the case of Koehler v Cerebos Australia have been handled by High Court due to a rising of negligence action of employer that have caused a psychiatric illness due to an excessive workload. The employee was originally being employed as a full-time sales representative. Unfortunately, during the employment, she had developed a psychiatric illness which was found to have been caused by her excessive workload. She have made a complaint about the matter to the management, but unfortunately there is no action taken due to her complaint. The commissioner in the District Court Western Australia investigation recommended that the work that is done by the employee was quite excessive. Furthermore, there is no action taken by the employer to assist Ms. Koehler and give assistance to the employee. The full court have decided that the employer could not have foreseen the psychiatric illness developed by the employee due to no specific evidence suggested that the employer should be alerted to the employee risk of psychiatric injury. Moving to the fact of the case, Ms. Koehler was given a territory listing, which means a range area determining the shop she have to cover on that particular day. I should mention here that Ms. Koehler worked 3 days a week as employee of Cerebos. Moving to the second point, the appealing party are genuinely worried that she could not perform the task given. But after several of months working, Ms. Koehler advising her administration again that her workload was excessively serious. She suggested that the challenges she faced can be lightning. That means she gives like a suggestion to the management by either decreasing the quantity of stores she visits or having her work on the 4th day. The appellant's work required her to lift cartons of product. On 2nd of October 1996, she reached the point where she felt she could not physically do that any longer, and she went to see her doctor, complaining of aches and pain and difficulty in moving. She thought that her aches and pain were caused by the physical demand of her job. Her doctor first focused on her physical symptom, then she was diagnosed as suffering a fibromyalgia syndrome. Now moving to issues raised by both parties, which is plaintiff and defendant. Plaintiff in this case is Ms. Koehler and the defendant is Cerebos Australia Limited. The appellant claimed that she became stressed from the unreasonable workload that was given and led to development of complex fibromyalgia syndrome and a major depressive illness. She made a genuine complaint with a suggestion to the management, but there's no action being made. Moving to the defendant's side, Cerebos Australia Limited, they, as an employer, could not foresee that the plaintiff was exposed to the risk of psychiatric injury resulting from her excessive duties at work. The employee have agreed actually in the first time to accept the duties and tasks given to her at work. The plaintiff also did not prove that she was at risk of suffering psychiatric injury as a result of performing her duties at work. Now moving to the conclusion, the High Court of Australia in Koehler v Cerebos formulated a fairly narrow test which appears to place more responsibility of the employee, which is Ms. Koehler. In this case, the employee was not found negligent, as the court found that the plaintiff failed to bring to the attention of her employer that she was actually suffering from a mental illness and continue her duties under her employment contract. The court emphasized and the contractual nature of the employment relationship, and the court found that because the employee continued to exercise her duties under the contract, the employee assumed the risk, and therefore the employer could not have breached their duty of care. That is, this was not reasonably foreseeable to the employer that the employee was at risk of harm. So that's conclude the case presentation, and we hope you enjoy watching the videos, and thanks so much for your attention today.